Professor M.B. Rajeev Gowda ji.
Thank you, Deputy Chairman, sir. Sir, in the Ramayana, in the Mahabharata, we read about royal couples who could not conceive children and had to use innovative methods to have children. In today's time, thanks to scientific advances, we have numerous other ways in which childless couples and others can have children, and surrogacy is one of the methods that is available to them. In a modern democracy, it's vital that these scientific advances are available to every citizen of India so that they too can have children using surrogacy when required. But in spite of the extended introduction of the minister and the detailed explanations that he gave, I'm not convinced that the bill in its current form is actually serving the purpose that was intended. I have filed a number of amendments, and I will explain how those would improve the bill, and I'm sure that the minister will pay attention to those and take it back to the other house where they have a brute majority, and they will be able to very quickly bring the amended bill back as a past the amended bill and turn it into an act. My concern is that the complicated rules and regulations, procedures that have been brought in here make it practically impossible for surrogacy to actually be used effectively by those who want to. There's a lot of red tape which is much more than you may have conceived of. So I'll first talk about the core contradictions in the bill. I'll talk about the provisions that are somewhat unjust, and finally add some suggestions for those provisions that are missing and need to be included. Let me point to the impracticalities of this bill, sir. So the first point, under clause 4, parenthesis 2 of the bill, it says surrogacy is permitted only in case the intending couple suffers from proven infertility. The Honorable Minister is a medical doctor. He knows that people don't have children or cannot conceive for reasons beyond proven infertility. There are numerous other issues. It could be an absent or abnormal uterus, premature menopause, recurrent miscarriage, or situations where it is impossible or unsafe for a woman to bear a child. These also are considerations that you should give attention to, because these are real medical challenges. And these are people who could use the benefit of surrogacy, and in the current situation, as far as the bill reads currently, they would be excluded. So I urge you to think about how to expand the scope for other medical indications of inability to bear a child. So clause 4.3b goes on to list a variety of conditions that the intending surrogate mother must fulfill. One of those is a term saying that she must be an ever married woman having a child of her own and between the age of 25 to 35 years, and a close relative of the intending couple. So this age restriction, these are all fairly restrictive. And let me explain how. What is this ever married woman? That is one of the questions that needs to be defined. And that 10-year period, women can have children for a period beyond that. And here, after all, you're implanting an embryo. So it is not a question of conception, it's a question of implantation. And in that context, the age limit could be increased, and that would allow for more people to be possible altruistic surrogate mothers. The other issue, which the Standing Committee also mentioned, is that the close relative clause creates a different kind of problem, a different kind of challenge. So in our family situations, this will create a situation where there's a lot of pressure on one of the relatives in the family to bear a child, because this is the family pressure, you're the close relative, you're the only one who can do it. Whether the person is willing to or not, they will be forced to do this. And that is a real challenge. So what happens? What happens to this desire to eliminate exploitation? You will be seeing more exploitation within the family. You possibly will see an increase in domestic violence. And this is an issue that is a reality in India, and the minister must pay attention to that. So there is also in the other challenge related to small families. Today, after decades of promoting small families, Where are these close relatives going to come from? If many people have just one child in the family, where are the brothers and sisters and cousins going to come from? That is also a challenge that you need to think about. So clause 4.3a, again Roman 3, mandates an insurance coverage of such amount as may be prescribed, etc., and provided by an insurance company recognized by the RRDA. No such insurance currently exists. In the absence of something like that, then it really becomes a challenge for all those other medical expenses to be taken care of. So either this has to be mandated to insurance companies, or one of the amendments that I've proposed, basically suggests that we should have a provision of a surrogacy agreement where all expenses, including potential expenses that would be covered by insurance, would also be covered. So, this, the minister also emphasized that the recommendation of the standing committee that a variety of different types of Indians should be allowed to have children, that proposal has been rejected. Why, sir? We're living in 21st century India. We're living at a time when Article 370 has been read down. We are living in a time when this is a time when people are single, people also desire having children. There is no reason for us to go back in time to some other era some Victorian era, where only married couples should be the beneficiaries of surrogacy. So single parents, live-in partners, divorcees, same-sex couples, couples where one of the partners is not Indian, that all of these are excluded, and there is no reason for this exclusion, and I urge you to be magnanimous. This is, after all, an opportunity for those of us who are already parents to share the same joys with those who want to be. So I urge you to make that change. The other aspect is in the wording. Many of my amendments change the term intending couple to intending persons in the singular or plural. And this would, just that change, would address this issue in a very, very straightforward manner. It becomes a much broader definition, it would be inclusive, and that should be the spirit with which we go ahead with a bill of this sort. So the other issue is about the costs, the compensatory versus altruistic surrogacy as you defined it. So fine, let us eliminate the exploitation of surrogacy mills and all those illegal activities that take place across the country. We do not want a single woman in India to be exploited as a surrogate mother in a commercial transaction. However, there are actual tangible costs that any woman who agrees to be a surrogate mother faces. And there is no reason, it would be exploitative, in fact, if you would ignore these costs and say, no, you have to give up your time, you have to risk your health, you have to give up your job and potential wages, you have to go through all the challenges of medical treatment, and without any of those costs being compensated. So we're not asking for anything in a commercial sense, but there are other costs. There are costs of clothing, there are costs of medicine, there are numerous such costs that must be taken care of. And those are not covered when you define altruistic in a narrow manner. So I would urge you, as we go ahead, I've also proposed an amendment on this front. So let us go ahead and not think that a woman's job is inherently to give birth. Let us make sure that those who make this grand gesture, who take on this extraordinary challenge, that they are also suitably, that the costs that they bear are suitably addressed. So I would basically argue that the sum should be an acknowledgement of the reproductive labor provided by the woman, and reasonable compensation should be provided. There is no reason I would think that the House would disagree with me, and let us see when the amendment comes up. So even the definition of infertility, if you look at the WHO's definition, it says 1 year. 1 year of, what shall we say, unprotected coitus and not having a child, not conceiving, is sufficient to be regarded as a ground for infertility. Here they've made it 5 years. That is 5 years of potential agony and tension. And therefore, it is incumbent upon the minister to be, again, large-hearted and in consonance. He quoted international examples. Let us look at what the WHO says and bring this 5-year period down to 1 year. So there is also the issue of abortion. Abortion here can take place only with the consent of the surrogate mother, which is fine. and on the authorization of the same by the state. Now, this abortion, if it has to take place, according to the laws currently in place, has to take place within a very short time period. There is no time limit for this government authority to give sanction to abortion if it is so indicated, if it is so required. And that would be a real problem if there is no time limit within which this decision is taken. And in this context, the Standing Committee made recommendations. And just like my colleague here is emphasizing, many of these crucial Standing Committee recommendations have been ignored. So let's leave this government entity approval out. The Medical Termination of Pregnancy Act, the Indian Penal Code, they have sufficient features in them that will ensure that the rights of the surrogate mother and, for that matter, the rights of the intending parents, that these are all taken care of. So what we need to do is possibly, as part of that surrogacy agreement, a tripartite agreement, we need to ensure that possibly there is a clause there which allows the intending parents and the surrogate mother to work out what conditions, under what conditions abortion would be allowed and what not. So, there's another issue with regard to storage. Again, sir, you're a medical doctor and I would appeal to your knowledge. You basically say that no storage of a human embryo gamete for the purpose of surrogacy is allowed. But sir, that the success rate of implantation is not automatic. It's not 100%. There are, women have to take hormone treatments for a considerable amount of time. There are numerous other challenges. The donated sperm has to be quarantined. So given all this, this prohibition of storage flies in the face of the medical requirements that would make this process possible at all. That's why I'm saying the rules here come in the way of making this practical. So that's the challenge. So there are, and in fact, these are the rules here, the details here are in violation of what the Indian Council of Medical Research has also mandated. So please, I've offered an amendment saying let's delete this section, and I would urge you to accept that amendment. So I would also say that we need to have a tripartite surrogacy agreement between the intending parents, the surrogate mother, and the authorized authority, and just a magistrate's decision on this part will not be sufficient. Most importantly, sir, it's extremely important to have informed consent on the part of the surrogate mother. Therefore, whatever consent related procedure we have, we must make sure that it is in the language that the surrogate mother, potential surrogate mother can understand, that there are friends or other people who can explain that this is exactly what that person is consenting to, because otherwise we may see exploitation once again. And so basically, sir, I would argue that we should also be a little more proactive. We provide tremendous maternity benefits in other contexts, in other bills, but here the intending parents will have to work with a newborn child. So we should have maternity and paternity leave of benefits of about 10 weeks at least for the intending parents. They have not gone through the medical process, the process of labor and delivery, but they still have to go through the process of bringing up an infant. Couple of other suggestions. So I have an amendment which says the birth certificate should bear the name of the intending parent or parents who commissioned the surrogacy. We should add definitions of the child, and so that child's rights are also absolutely taken care of, and that includes bringing in aspects of people who are of Indian origin, persons of Indian origin, overseas citizens of India, etc., so that the child who is born here has the option of becoming an Indian citizen. So I hope you will agree that these suggestions that I've made, the amendments that I'm going to propose, that these are all constructive. They are aimed at achieving the same goal that you have, which is to end commercial exploitation, to make surrogacy available to couples or persons of a variety of sorts in a very inclusive manner. The aim is that the joys of parenthood should be available to everyone, every single Indian who seeks to be a parent. So I hope that you will be able to accept these. You will urge the House to also go along with that, and I urge you to go ahead and accept these amendments when the time comes. Thank you for this opportunity to be constructive in this
Thank you,
speech.
Rajeev
Thank
Gowda
you.
ji.